Perfect. Hello, everyone. Okay, let me start the slideshow. All right. So today we're going to talk about some general HR issues that result in lawsuits for employers. And so I've broken them out into these kind of 10 general topics. Some of them 100% intersect payroll. Sometimes these are things that people come into the payroll department or come to payroll technicians with questions about that aren't necessarily stuff that they are attuned to knowing the backstory of or have all of the specific information for. And so that sometimes also results in future HR issues or lawsuits. So the first thing we're going to talk about is meal and rest period breaks. So honestly, these are some of the most common violations that we see from an HR standpoint that result in either complaints to the state labor boards or in actual labor litigation lawsuits. So these result from individuals not receiving their meal or rest breaks correctly, whether they have chosen not to take that and are improperly recording that, or a manager is interrupting those. And so really understanding what the law is and how those are applied to your industry is super important. With the meal break issue, that is pretty cut and dry. If the employee is out on their meal break and that meal break is interrupted, that cancels out that meal break. So that 30-minute of uninterrupted time really has to restart. And so if it's a one-off occasion, that is probably not going to result in a lawsuit. If it is a continuous issue for an organization, either through one employee or through a particular branch of an organization or a department of an organization, that's where it becomes a much greater issue. So really these issues stem from the root causes of poor timekeeping management practices, lack of organizational policies, and then training managerial staff on what those actual policies and procedures are and how they're applicable to their general departments. So a good example of this is rest breaks. So there are situations where based on the type of work that the employee does, they really need those scheduled 10-minute rest breaks. And so you're going to say, employee A, you're going to take your break at 10, 20 every single Monday, Wednesday, Friday. And on Tuesday and Thursdays, it's going to be at 10:40. And so you're going to schedule out those interval breaks. You're also going to have, situations potentially where you have employees that are, much more administrative in setting and type. And so they're taking those rest breaks as they choose. And so they're getting up from their desk to use the restroom, to go to, a community break room, to run out to their car, to make a personal call. And so they're on a much more flexible rest break schedule. And so understanding both what the law is and then how it applies to your type of employees and their work really is crucial to avoid meal and rest break type issues. So the next most common issue we see is independent contract status. So this comes from both the misclassification of employees or employees who are what we consider dual status employees. So those are employees that are working both as an employee and as an independent contractor for the organization. So as far as someone being an independent contractor versus an employee, here's a quick table that I have put out before to help reference kind of what this different breakdown is. So employees are generally paid hourly or salary. They use the employer's materials and tools. They work for, one employer. And if they work for multiple employers, there's usually provisions within the first employer's work documents that are stating that there's no conflict of interest, or that the priority of the first employer is going to be held higher than subsequent secondary employers. There is a continuing relationship. So the idea that the employee is going to come back day after day, week after week. The employer decides the manner and means of performing work. So that is really directing how a task is done, not just saying that we need a task to be completed. So then on the independent contractor side, that's the complete reverse. So they're paid based on the completion of a project or the number of hours worked on behalf of that employer. They provide their own materials. They generally work with a multitude of clients. That relationship is temporary. So it's either based on a particular project or scope of work, or it has a contract that has a timeline in place or provisions for both the contractor or the employer or the client to exit the contract. So then the contractor is the one that decides how a project is going to be completed. So if they want to complete that project at 2 o'clock in the morning versus 2 o'clock in the afternoon, that's on them. And then the contractor and the client are the ones that agree on the scope of work or what that project is, not solely what the employer potentially or the client wants to do from an employee-employer relationship. So when we look at these situations, usually the majority of issues result in employees not understanding the Fair Labor Standards Act, which kind of talks about what this employer-employee relationship is. Then there is also the issue of there's not really someone within an organization looking at all of these positions or all of these contracts. And so there might be an organization which is just big enough to have multiple departments, but not necessarily big enough to have an HR department looking at some of these issues. So each department manager is trying to independently make these judgment calls. And so across the organization as a whole, there's not a lot of meaningful or what the courts are going to consider a standardized policy that is being administered. And so then that comes to the lack of organizational policy. So if you have departments doing things in a variety of different ways, that can create a multitude of different issues for your organization. And so especially with independent contractors, if they're determining who is an employee versus who is an independent contractor in 15 different ways in an organization, that's what can really open someone up to potential liability. So then you also have employers who potentially have situations where they have employees who are acting both as employees and independent contractors. If that is a situation that your organization is in, or you have clients who have that as a potential situation, make sure that they are actually getting legal advice from Michael Santos or another law firm on the Western Slope or in Colorado that specializes in that, because those relationships between employees that are acting in a dual status or a dual role within an organization can be very tricky and can also open an organization up to a ton of liability. Because if you are not calculating that stuff correctly, or an employee is using the resources of the firm when they should as the independent contractor, be using the resources of their independent organization. That's where some of these relationships end up becoming very sticky and very contentious. And so having legal advice from the get-go, if that is something that you potentially are going to look at doing from an organizational standpoint, is extremely important, because as a payroll processor or someone who is running both payroll and accounts payable, you want to make sure that these individuals are getting processed correctly, and you're issuing 1099 when that should be issued versus, a W-2. And so making sure that those wages are correctly classified and everyone is under a full understanding of what they're obligated to do as an employee versus what they're obligated to do as an independent contractor is vitally important in these situations. So the next real big sticky issue is harassment and discrimination. For the most part, this does not intersect a lot in payroll, other than payroll having these type of issues as employees themselves, and really having to kind of work through these issues. So I just wanted to provide you guys with some general information about both of these topics. I think it's really important for organizations to understand that harassment can be a multitude of things. And so when you look at what potentially is going to result in a lawsuit for an organization, it's not necessarily just sexual harassment or sexually inappropriate comments that might result in something. It can also be, the bullying of coworkers, and organizations not really taking that type of situation seriously. So when we look at what normally results in harassment complaints, some of the biggest issues really seem to back from that original, organizational structure of not having sufficient policies to deal with some of these situations, lack of training from managerial staff, so them not realizing the severity of the situation, or quite frankly, them being young or new managers who have not had the experience of dealing with subordinate employees who are having these type of issues. So really making sure that those tools are in place so that managers feel supported in working through some of these types of complaints or issues. And then really making sure that they understand that prompt action is so important in mitigating an organization's risk for these types of situations. The other major issue is that when something does happen and an organization responds to it, they have an inappropriate response level. And so when someone really should be put out on, paid administrative leave pending an investigation, they move that person desks. And that's kind of an inappropriate response. And so when something ends up being settled, or a lawsuit is filed potentially from an employee, then that's what a court or an arbiter is going to come back and look at and say, like, okay, during this period, this person really should have been removed from the work environment or the work situation, and instead, they were just put on a different shift, and that then opened that shift up to potential liability or harm, potentially based on what that employee's actions had been. So as far as discrimination goes, the 2020 report just came out from the EEOC. They run, the federal fiscal year, October to September. So for their 2020 fiscal year, they had 67,448 charges of workplace discrimination that they investigated. So as an agency, they actually secured just under $440 million in findings for their victims, both in the private sector as well as state and local governments. So below is kind of the chart of what the findings broke out to. So the biggest one continues to be retaliation. So having effective policies within an organization that deal with retaliation is becoming more and more important, especially in mitigating an organization's future liability if they have potentially had a finding or are going to have a finding. And then disability, race, sex, age, national origin, color, religion, Equal Pay Act, and then genetic information all continue to be areas that the EEOC has findings, though equal pay, religion, and genetic information have historically come in under 5% of the findings. So work hour issues also continue to be a big issue for organizations, mainly because supervisors and employees can sometimes be unclear as to what they have to record as far as time worked. So this really becomes important for your non-exempt employees who are getting paid an hourly wage. A lot of times, you think you have an employee who is doing things out of the goodness of their heart and are taking on extra tasks or extra projects on the weekends or before or after work for the good of the company. And they're actually, keeping track of those things. And for the most part, everything's fine until there is something that upsets the turnip truck. And that's when the employee files a suit and then comes back and alleges that they did all of this additional or extra work outside of work time and were not compensated for that. So managers really need to be aware when employees are hourly and on site outside of their shift times, or when they are potentially doing things to benefit the employer outside of those shift times. So in one of my prior roles, we had an employee who on a regular occasion would take care of all the office plants at a particular location for that employer. And they, would repot all of the plants. And, it was just something that had gone on for 5 or 10 years. And everyone just thought that person really loved taking care of the plants. Well, that person in an employment lawsuit that they later filed alleged that they had been working all of this time that they should have been paid overtime for, that they were repotting these plants and that should have been work time. And so really understanding the difference between when someone is volunteering and making sure that all of the parameters are clear as to what is a volunteer activity. So sometimes, organizations have a charity of choice. And so on, a Saturday, they might all group and go to the March of Dimes walk, versus, that being an actual paid employment activity. Those parameters need to be in place long before that activity happens so that everyone is clear as to what is a compulsory work activity versus what is a volunteer activity. The same goes with travel time. And so in Colorado, under our comps order, we have some pretty specific provisions about what gets calculated as travel time. And so if someone is, flying from Grand Junction to Dallas for a work conference and they get stuck on I-70 because, you as the employer had them route that flight out of Denver and Glenwood Canyon is stuck, guess what? You're paying them for that extra travel time. you are not paying them for stuff that they are normally not doing as work-related activities at a conference or on travel. But if you're requiring them to go to a dinner or a luncheon or a breakfast as part of a conference, you're paying for that. You're not paying for them to go to Disneyland if that conference happens to be in Anaheim. But if you're requiring that they go to Disneyland as part of that conference and take some clients there, then you're paying for that work activity. So once again, really with hours worked, the issues stem back to understanding what the law is and how that is applied, having policies in place that are fairly and equally administered, and then really working on having those sound practices in place for timekeeping. So then leaves of absence. This is kind of the next big category that comes into play. So the issues, really stem from non-compliance of the law. So that non-compliance could be for a variety of different reasons. One, they could just generally not understand what the law is, or, what types of leaves of absence apply to their size of employer. Sometimes it's the employer is growing or shrinking in size, and so they are, coming through the changes of those categories and might be missing things. Sometimes it's just not really understanding all of the different types of leave, or how those are applied. And so that leads to kind of the misapplication of different types of leave. So we'll take the Family Medical Leave Act, for instance. So a lot of times employers that are subjected to that particular leave law based on the size of their organization, they end up, really because of the size of their organization or the complexity of the organization, end up having a lot of frontline managers apply the Family Medical Leave Act to their individual employees, as opposed to that stuff running through a general compliance officer or through HR. And so, you may know that you have to do FMLA, but you may not know as that frontline manager that there's a series of forms that you have to send out. Or you may not know that the employee could be eligible for intermittent FMLA. And so that's really where the misapplication of the various leaves of absences come into play. The other areas that we see right now with the biggest misapplications are kind of that COVID new sick leave time here in Colorado. Then the COVID leave when that was really popular last year. And then military leave, that also seems to be an area that has a lot of confusion. So the next big issue that we see with leaves of absences is that organizations have inconsistent applications of those leaves. So once again, if you have multiple departments kind of managing how they do these leaves, you leave yourself open to those managers, doing the leave in various different ways, which then, based on classification or group of employee, could end up getting that organization into a great amount of trouble, just based on the fact that employee types or classes of employees need to be treated the same. And so if you have non-exempt employees who, based on what department they work for, who their particular manager is, or if the manager likes them or doesn't like them, is deciding how much leave they're eligible for or when they can take leave, that ends up being a huge issue for the organization. So, once again, I think most of these areas have similar root causes. This one, once again, is a misunderstanding, I think, of the law or which laws apply to an organization. The lack of a compliance officer or organization that is managing that for the employer. The lack of organizational policies that really are adhered to on a consistent and you know, uh, a meaningful way, because sometimes organizations say that they are complying with their policies, but when you actually look at how they have applied and actually administered their internal policies, it's not an equal situation. And so that's really where you look for that equitable administering of policies across the board and across departments. And so once again, you kind of have some timekeeping issues with some of these leaves of absences. So being aware on a payroll side of how some of these things might affect your organization is really important. So some organizations have policies that when someone is out on a leave of absence, that means that the employee is responsible for covering their portion of their benefits that they normally would have been responsible for paying. And so if you are collecting that from some employees and not collecting that from others, that is an area that could potentially result in litigation for your institution or organization. So then we kind of come to termination and final paycheck issues. So there's always going to be issues with employees alleging wrongful termination. So as an organization, one of the best things that you can do is really document, go through your coaching and annual review processes. If you have a performance improvement process, make sure that that is being used consistently time after time, so that when you have an employee who alleges wrongful termination because they say that you're terminating them because of age discrimination or a pregnancy or whatever that might be, you can come back to the actual documentation of why they were terminated and proceed that way. That also kind of kicks back into unemployment issues. So just because someone doesn't necessarily file a wrongful termination lawsuit against your organization doesn't mean that they're not going to file an unemployment action against your organization. And so once again, having these documentation, protocols in place from the get-go really helps not only support your managers, but support the overall organization in fighting these type of employment actions. So then you come to the issues of actual termination and final paycheck issues. So sometimes organizations will deduct from a final paycheck because someone did not turn in keys or did not turn in a vital piece of equipment. Making sure that that was documented and that you have all of those policies in place so that you can deduct that from an employee's final paycheck is super important, because just deducting it and then hoping that the employee doesn't come back and fight it at a future point in time is, a very risky action. And so if you are going to potentially be deducting things from someone's final paycheck, make sure that you are getting that fee schedule in writing and signed beforehand so that everyone is clear that if they don't turn in their radio, they're going to be assessed $120. If they don't turn in the keys, that's $40, or whatever that particular policy looks like for your organization. So then this comes to the next kind of general topic, which doesn't necessarily tie to that final paycheck, other than that being a subcategory of this particular issue. But you also have deductions from wages that come from issues of improper calculations or just improper deductions. So sometimes employees really don't understand what they are signing, or you have situations where employees are lazy and they have other employees fill out their paperwork. And so that can lead to improper calculations that are then the responsibility of the employer or can result in employer lawsuits. So one particular circumstance that I am aware of, an employer had an employee who was their payroll technician consistently fill out paperwork, not only for how someone was filling out a W-4, but also their benefits paperwork. And then the employee was just coming in and signing that based on what the payroll technician had filled out. And so it was a pretty easy case when the employee filed the lawsuit and the courts went back and kind of looked at all of the documentation because they audited all of the records of the organization. And when about 50% of the paperwork was all filled out in the exact same handwriting in the exact same purple pen, it was pretty clear that each employee was not filling out their paperwork. One employee was filling it out and then having everyone else sign it. So that can lead to, as I said, a multitude of different issues and really some of those improper calculations. Also, really understanding the work status of some of your employees. So if you're going to hire someone who, potentially is working internationally, understanding what those ramifications are for your organization so that everything gets put in correctly from the get-go can be super important. So as far as improper deductions go, on the time side, we see this more for exempt employees. So someone who is getting an amount of money for completing a task within an organization, regardless of the number of hours it takes them to complete that task, I think is the best way to kind of think of exempt employees. And so sometimes for exempt employees, it takes you 80 hours to complete those tasks. And so you are not compensated overtime for those additional 40 hours. Whereas sometimes in a work week, it might take you 35 hours or 38 hours to complete a task, and you were still paid for those full 40 hours. And so organizations often have issues with improperly deducting days off or time. So employers can typically deduct if an employee is off for an entire day. But if they have worked any portion of the day as an exempt employee, then they are typically paid out for the entire day. And so really understanding how the exempt issue impacts time is important as well. There is also issues on occasion where items are improperly deducted from employees' time or wage calculations. And so really understanding how frontline managers are putting things into the system, or when they ask payroll to deduct something from the wages, really making sure that that is a legitimate and legal reason for deduction is super important. And then as we talked about in the section previously, those final paychecks can often, result in some unique issues, and making sure that those final paychecks are issued in accordance to the time provisions that they need to be issued in based on how that employee exited your organization. So, Manon, I think the second question applies to this one. Let me double check.
I'm going to open up the polls. So if it doesn't instantly pop up on your screen, down along the bottom panel of your Zoom browser, your Zoom application, you'll be able to click on a button that says polls and open that up and answer question number 2.
Okay, so you know, the next kind of big issue that hits oh, sorry, I lied, Manon. It'll be the next one. I apologize, guys. So, illegal and discriminatory hiring practices. This, once again, doesn't necessarily intersect payroll a lot outside of some of the new laws we have in Colorado. And these can potentially be issues for your own departments, or how you guys interact with other departments within an organization. So right now, the 3 biggest areas we see for illegal or discriminatory hiring practice lawsuits are issues with applications. So applications just asking things that we're not allowed to ask, like dates of birth. You can ask if someone is 18 or older and can, perform a certain task, or 21 if that's what the particular task requires. But you cannot ask for someone's date of birth. Now in Colorado, it is also illegal under the Equal Pay for Equal Work Act to ask what someone's prior wages were, which was a very common question that we saw on employment applications in Colorado. So as of January 1st, employers were supposed to have scrubbed that question off of their applications. And we are still seeing employers with applications asking that question. The next kind of section we see is the actual interview itself, and debacles that can happen during the interview process. So up on the screen, there's a list of questions and categories that nationally are illegal that we just can't ask anymore. Once again, wage issues in Colorado have also added to this list. So if you're asking any question of an applicant around their religious beliefs, that's probably a no-go question. Now you can ask an individual after they are hired if that employee requires any sort of religious accommodation, but you cannot ask that question as part of the hiring process. You're not supposed to ask if someone is married, how many kids they live, or how many kids they have, how many kids they plan to have, how they plan to care for those children. Those are all questions that will automatically red flag an interview and can potentially result in litigation. So then now with hiring practices under the Equal Pay for Equal Work Act, employers need to be very conscientious of the wages that they are offering employees as they are bringing them into an organization, and making sure that they understand not only how that wage compares to all of the other employees that are currently in those positions, and how the skills or educational background of the new applicant kind of weigh to all of the other credentialing and matrix information for your organization, so that people are being slotted in the correct pay category, as well as your existing employees being paid correctly based on their skills, years of applicable service to your organization, or additional certificates, or different trainings that they have maybe received over the years that they have been with your organization. So once again, really understanding what the laws are concerning hiring practices, understanding who is handling these issues for your organization, and making sure that there's kind of a general theme that is being followed, so that, if departments are handling interviews separately, there's common forms that they're following, that they're being provided training, so that they are interviewing each applicant the same way every time, so that there's not issues on that end. And then really, as an organization, working on your policies, so that your managers feel that they're supported, and have the policies and procedures to be able to turn back to, when they go through these different activities. Some departments may hire on a regular basis, where you might have other departments within your organization that might only hire once every 2 or 3 years. And so really understanding how to support the spectrum is super important. Okay, I can't forward my screen now, man. Oh, there we go. That was just me. So overtime calculation. So I think the poll can come back up now. The Fair Labor Standards Act really is what calculates or drives how the calculation of overtime is administered nationally. And then the Colorado Comps Orders is what administers or drives how Colorado has all of our overtime provisions. So when we look at overtime issues, one of the biggest things that we see is that organizations aren't accurately keeping time. So that goes back to the issues of, that nice employee who is potting plants and not accurately writing down their time. Those can be issues. You can have issues of managers telling employees, I need you to work these extra 15 minutes, but don't write down that time because our department can't have overtime, but I need you to work anyways. Those can all result in timekeeping issues that will result in litigation. So really going back to, training those managers of, the importance of accurate timekeeping, as well as what the consequences are for violating the Fair Labor Standards Act, is vitally important. So then you have issues of common ownership. So based on the type of organization that you have, or maybe the ownership structure of who owns your actual organization, you could potentially have a situation where you have what is known as common ownership under the Fair Labor Standards Act. So this is an entity or maybe a business owner who has more than one operation that, based on the activities performed, are considered to be unified or common in control. So this could be a business owner who owns a KFC, a McDonald's, and a Dairy Queen. And so they have a manager who works 40 hours normally for them over here at Dairy Queen, but there was an issue over at McDonald's. And so they picked up 20 extra hours at McDonald's. That's not an issue of them getting paid 20 hours of regular rate at Dairy Queen and 20 hours of regular rate at McDonald's. That is now common ownership based on how that ownership structure is set up. And so now they are actually paying 40 hours of regular rate for those hours at Dairy Queen and 20 hours of overtime for the hours that were assisted in the other position. So you also have organizations who have employees or multiple departments who may have employees that cover in those departments. So if that is a coverage situation, it is 100% common ownership and you were paying overtime. Sometimes you have an employee who works multiple positions for your organization. So take the city of Grand Junction. You could have a nice, individual who's working as a benefits specialist in HR. And then 20 hours a week, they love to lifeguard on the weekends. And so that's their jam. They pick up an evening shift on Wednesday nights and 2 weekend shifts. And so they're working for the city of Grand Junction in 2 different departments under common ownership. Even though those 2 positions are vastly different, HR and lifeguarding, they are now under the premise of common ownership, having to be paid overtime. And so then that gets to the overtime calculation issues. Really, under Colorado, there's 2 permissible ways to pay those overtime calculations. And so making sure that the employer's systems and situations are set up to accommodate that if they have employees in those multiple pay categories is really important. So, I think, as I said, this all kind of comes back to those root causes of understanding what the laws are, specifically the federal laws, and then how Colorado may have enhanced those laws through our comps order or through any other legislative policies that have come out. As an organization, having organizational policies to determine how the organization as a whole wants to handle some of these situations. So I have clients who, as an organization, have policies in place that say, you hold one position within our organization. We don't want you to have multiple positions within our organization to make it very clean as to what you're doing at what time. And so if you're an organization that does decide that it's okay or permissible to have employees act in multiple positions for your organization, you really need to have the policies in place and the mechanisms to help your management or any supervisory employees determine when that subordinate employee is acting in what role, and then how they're going to be paid. So is any overtime going to be a blended rate? Is it going to be the rate for the hours in which they were kicked into overtime? What's that going to look like? And then how are those policies going to be administered equitably across your entire organization if you end up having multiple employees in that type of position? So the final, big issue really comes down to how employees are classified, whether they are exempt or non-exempt. So exempt being employees who are not eligible for overtime, non-exempt being employees who are eligible for overtime. So really, it comes down to how these employees within your organization are classified. In Colorado, if you are going to be an exempt employee, there are the Fair Labor Standards Act duty tests that are part of that order. And then Colorado has modified that. And that is what you see on your screen now. This is the duties test for Colorado. So in Colorado, for someone to be an exempt employee, meaning that they are not eligible for overtime, under our comps order, they have to make a certain amount of money, which over the next couple years is going to raise in roughly $5,000 increments until 2024, when that hits $55,000. And then any additional increases each year will be set by the Consumer Price Index. So they not only have to make the wage threshold to be considered an exempt employee, but they also have to meet the duties threshold. So the state of Colorado says that for you as the employee to give up your right to overtime, what you do has to fall into one of these 10 categories. So this will be your poll question number 3. You know, these categories are so important that basically the state of Colorado has said these are the only permissible reasons that someone can give up their right to overtime. And so the top 3 are the ones that we see the most: administrative employees, executive or supervisors, and professional employees. So to be an administrative employee, the state of Colorado is basically saying that you directly serve an executive and regularly perform duties of importance to the decision-making process of that executive. The executive employee must regularly exercise independent judgment and discretion in matters of significance, so that is of material importance, with the primary duty that is non-manual in nature. So then an executive and supervisor employee, the state has made that very clear that to have that duties test satisfied, that person needs to manage at least 2 full-time employees and have the authority to hire and fire those employees. So it's not just enough for them to potentially be a shift supervisor who doesn't have the authority to hire and fire. They must have that level of authority. And managing those employees must be at least 50% of that person's work week, which makes that a very, tough threshold to pass as significance or a level of duties compliance. So then for professional employees, these are employees that have a level of education and particular type of work that relies on consistent exercise of discretion and judgment, that is distinguished from routine work that is mental, manual, mechanical, or physical. And they have that knowledge of an advanced type in the field of science or learning, customarily acquired by a prolonged course of specialized intellectual instruction or study. I know that's a mouthful. So basically, that is saying that you have sought some sort of additional training to be in that profession. So a good one in your world would be a CPA versus a bookkeeper. So typically, bookkeepers within an organization will be classified as non-exempt, where a CPA would be classified as exempt due to their prolonged course of study to specialize in the work field that they are doing. So all of the other provisions are listed that Colorado will consider for someone to potentially be exempt from overtime pay. But as I said, Colorado and all of the states at this point are very clear that if an employee is going to give up their right to overtime, what they are doing must be pretty darn special. And this is what the state of Colorado currently lists as those reasons. I will jump back just a moment because I realized the last poll question had to do with the Equal Pay for Equal Work Act here in Colorado. If I can find that slide again. Maybe. So in Colorado, we are not allowed, or nonprofit organizations are not exempt from the duties tests here with the wage classifications or for overtime. And so that is something that has been a question the last couple years with how that comps order rolled out for the different pay categories, milestones that were going to be met for organizations, both for-profit and nonprofit. When that particular section of the comps order rolled out that had the specifications for wages for non-exempt employees. So that came out in that last comps order, comp order 38. We're now on comp order 39. It it really had some provisions in there because it came out mid-year that based on the size of your organization, both profit or nonprofit, you had to make certain provisions by July 1st. If you met certain size provisions, and then January 1st of this year, if you were below those thresholds. And so unfortunately, the way that that was written into the order, some people had misinterpreted that into thinking that nonprofits were fully exempt for the wage provisions with the non-exempt employees, which is just not the case. And so that has had some pretty large ramifications on nonprofit budgets because nonprofit employers are responsible for complying with the wage components now of the Equal Pay for Equal Work Act and the components of the comps orders here in Colorado. So in general, my recommendations to you guys of how to avoid HR lawsuits, especially ones that pertain to payroll or payroll processing, is make sure that you are documenting. That is so important. If you, as an organization, ever have some type of employment lawsuit, making sure that you have all of the pertinent emails between you and the employee, detailing any action that was taken or why actions were taken. If you've had a verbal conversation with someone, it is always best to recap that conversation in a email to document what that looked like. So that you have some of these documentations as support when you go into a labor issue. Make sure that you are constantly training your managers and employees. So this is vitally important for, especially sexual harassment, but really runs the gamut from, any type of harassment to work safety, to how you want them to document things, to how you want them to go about, standard operating procedures within their particular department. There is never enough training, especially with new managers or new supervisors. Sometimes we take for granted that someone just knows how to do something, and that might be the first time that they've ever had to discipline someone, or the first time that they've ever had to write someone up. And so making sure that they have the tools to be successful in those type of actions is super important, and just not taking for granted that in those employment actions, someone is going to feel comfortable or have the knowledge base of prior experience to really feel comfortable in working through those. Complying with the law, that seems like it should be obvious, but for a variety of reasons, organizations just don't comply with the law. And so that will nail you every single time. You have no affirmative defense if your organization is not complying with the law. And at that point, you should just settle the case because you are definitely not going to win in court. make sure that you educate not only yourself, but you make that a priority for your employees, especially those with supervisory responsibilities, that they are staying abreast of what the current federal, state, and local laws are, what's going on in your particular industry or your clients' industries, so that you have an understanding, really of how the current laws are applying to various situations within the organizations that you manage or you assist. And then maintaining consistent policies. This one, as again, should really be a no-brainer. When you have a policy in place, that should be the policy that is followed. But oftentimes, because of the way that organizations are set up, and because of human nature, a lot of times policies are not equally or equitably administered, and so you wind up with employment lawsuits because this person was treated this way and this person was treated another way, and especially if that person can potentially claim a discrimination portion of anything that is a protected class in the EEOC, that's an enhancement to their lawsuit, and can really come back and end up biting an organization in the long term. So with that, does anyone have any questions about any of this stuff in general? Normally when I talk to large groups, one of the first things I ask is, what do you hate the most about HR? What scares you the most? Because that really is where people's comfort levels end up lying. And it's one of those things that if you don't do a lot of HR work or you don't have to deal with employment issues on a consistent basis, it ends up being a very daunting or scary task as you move forward in some of these one-off situations that end up coming up.
I'm just going to say there's so much detail to HR, to benefits. Yeah, benefits, and there's COBRA, and oh my gosh, it is an exhausting process.
Yeah.
Yep.
And something that's always changing. And if you
Yeah.
are an organization that is practicing in multiple states, that
Yeah.
only magnifies it exponentially as you grow and you scale. Colorado, I will say, is rather progressive right now in our HR laws. And so where California used to really set the trend in HR and employment law, we're not that far behind them anymore. And so that is, I think, both a good and a bad thing, as we've seen how things have progressed over the last few years. I think from an employer side, it's made some things much clearer, but has also put a lot of additional liability on organizations. I think a great example of that is how the Equal Pay with Equal Work Act was passed. Normally when you file a labor or employment dispute with the state, you as the claimant have to name yourself and you have to show how you were potentially wronged by that action. Now with the Equal Pay for Equal Work Act and the wage components that fall under that, individuals can now make anonymous complaints on the state website. So you can take a screenshot of someone's employment ad and file a complaint. And so it's made for some really interesting issues. I think a good portion of complaints that have been filed under the new law in the last few months have been a mix of I would say disgruntled former employees, as well as some competitors. So that's something that in Colorado, up until, 7 months ago, we really haven't had to deal with before. And so that's been a very interesting change to the employment landscape, and really making sure that people are diligent about posting that wage range for open positions is super important. Any other questions, thoughts?
So I've had a question about the vacation payouts,
Mhm.
and I'm curious about what do you think that the ability to cap or limit carryover or anything like that is going to be in the pipeline? Like I'm curious where that's going to go.
No, so I mean, I think the biggest thing that we have seen is, what Governor Polis signed into law last year with the sick time, and how that was mandated in. What employers have always kind of skirted that line with is, if you technically call something vacation, then you are paying that out when someone terminates. And so having those separate banks of time over the years have been really important to how organizations have been able to operate. And that has continued to kind of be the trend in California. So I see that continuing to kind of be how Colorado trends. The issue is really an organization having the ability to either be large enough or have sophisticated software, if they are a very small organization, to be able to track all of those separate banks, right? And so I think for smaller organizations, that's where they've gotten in trouble over the years, is it's easier for them to administer a vacation, a sick, a PTO policy, whatever they want to call it, where all the time is lumped into one big pot. But then they end up paying that out on the back end if they don't have, buyout policies in place where that's turning over every year. And so really, as an organization, being diligent to how some of these payroll issues end up affecting your long-term bottom line is really important, because, I worked for a county where commissioners over the years, to rectify not being able to give raises or give cost of living increases, did really increase vacation pots. And so you ended up with employees who had large amounts of vacation set up, but when the county went through the budgeting process every year, they weren't taking into account from a budgetary standpoint that pot of money that was actually sitting over in vacation that they would have potentially had to pay if 40 employees would have walked out the door on the same day. And so while that was a unlikely scenario, with how employers and different industries operate, that's not something that was an unheard of scenario. That could have been a situation where, based on, mills or factors at the mine and assessed valuation in a given year, that the county would have had to have layoffs and furloughs, which would have resulted in them paying that out. And so really being mindful of all of those factors and how they kind of play into an organization's overall books and overall, methodology and pay philosophy is really important.
So I have a question regarding that very same topic. So if in an employee manual, it says at 3 years, or sorry, at 10 years, the cap is 320 hours, clearly in their
Yes.
employee manual. But they didn't cap it in their payroll software. And so then somebody has in excess, say 400 hours, and they've rightfully accrued that. What are
Right.
some suggestions on how an HR professional could diplomatically solve that problem?
So a lot of times, that will come up in, a payroll audit, or a compliance audit showing, that someone has exceeded what a policy is in place. If it is a one-off situation with just one employee, that's much easier to handle. That's usually a matter of, back training, how that potentially ended up happening, whether that was, a software glitch or something not being enabled correctly within the software. That's much easier to solve. But if it's a situation where, they just let this kind of run amok and there's, 10 or 15 different employees with a greater outstanding balance, that's when the organization really needs to do an organizational reset. They really need to, as a board or as a governing body that manages that organization, repass what that policy was, whether that's the handbook policy or an internal management directive that came down that this is what the benefits policies are, so that shows what it is. And then those employees that had the excess balance, they are grandfathered for a particular period of time, and allowed to spend down their balance until they reach what their cap is. And then they are not allowed to accrue above what that cap is.
Okay.
Does that make sense?
It does, and I appreciate your comment. Thank you.
You're welcome.
Lots of useful information today. Manon, are we over time, or how late does our meeting go? 1?
We are over time.
No
Whitney,
more
thank you so much for
Not a
your time today
problem.
and sharing your expertise, and it was a wonderful presentation. So thank you so much.
Yes, thank you. Thank you everyone
Whitney.
for having me, and have a lovely afternoon.
You too.
Thanks,
Take
you
care.
too.
Bye.
Bye.